We're going to talk about habeas corpus, which is a procedure and a type of case that you use to challenge the legality of detention. It's not really supposed to be used to challenge the conditions of confinement. If there's a medical issue and you think your client's not getting adequate medical care, a lot of people will file a civil case under the Rehabilitation Act. But for challenging the legality of immigration detention, habeas corpus is what you want to use. The statutory basis is a couple of statutes, but the main one is 28 U.S.C. 2241. That's the statute that lays out jurisdiction and the cause of action for habeas in federal district court. Sometimes you also see people plead the suspension clause in their jurisdictional sections. The suspension clause of the U.S. Constitution. One really nice thing about habeas is there is a special procedure for starting a case. And this procedure gets used by most judges in my experience, but not every single judge. And it's called an order to show cause. The order to show cause is specifically provided by 28 U.S.C. 2243. And what that statute says is that when a district judge gets a habeas petition, they're supposed to review it promptly. They can dismiss it if it seems like there's no right to relief here. However, if not, then they're supposed to order the government to show cause why the petition shouldn't be granted. The government is supposed to be given 3 days. That's the default, is 3 days to respond. However, they can be given additional time up to an additional 20 days. So theoretically, if we're doing an order to show cause, the theoretical maximum time that the government gets to respond is 23 days. There is a set of habeas corpus rules, and the name of those is Rules Governing Section 2254 Cases in the United States District Courts. There's also a set of rules for Section 2255 cases. Now those statutes are not the statutes that we use for immigration habeas cases. So those rules by their own terms, they don't apply to immigration habeas cases, but judges have the discretion to apply them to immigration habeas cases. So judges will look at those rules, especially for things like discovery. So if you're going for discovery, which is allowed in habeas, you want to have a look at those rules. One threshold requirement for habeas is that your client has to be in custody. How do we know that our client is in custody?
Are they free to do what they want?
Right. So let's start with the obvious case. If they're locked up in detention, then they're obviously in custody, right? I would say that, more peripheral cases, if your client has an ankle monitor or they're on an order of supervision, that's a significant restraint on their liberty. You might have a good argument that they are also in custody. Let's talk about the immediate custodian rule, quote unquote rule, because it's not really firmly established that it's a rule in immigration habeas cases. But the immediate custodian rule or idea says that the person we're supposed to sue, the respondent, is the immediate custodian of the petitioner. And usually that means the warden of the facility where they are detained. That can be weird in the immigration context where so many people are detained in private detention facilities. So it's like you can sue an employee of the GEO group and argue that they are, the immediate custodian. And, I think the treatment of this differs, in different parts of the country. If you're new at this, the best practice is to sue the warden of the facility and to also sue the ICE field office director.
What I do is I sue the warden by title. I say warden of the Houston Processing Center.
Exactly.
I don't list a name. I list a title, the location, and I file it as quickly as possible because they are moving people every day, every 2 days. The judges, in my experience, are going to say, when was the petition filed and where was the person at that moment. If they were in the district at that moment that the petition was filed, there's jurisdiction. If not, the judges might say, no, I'm going to dismiss it, or maybe you're lucky and they transfer it. But you really are better off having a quick and dirty petition, even the form for 2241 petitions, file that as quick as you can, because a great lawsuit put together that's filed too late has no effect whatsoever.
Yeah, and you're allowed to sue people by their title under FRCP 17D. And in times like these, when we're seeing a lot of turnover, I've started recently just only naming people by their title. It's just faster than having to change the pleading every time the government officer switches. It saves you from having to research who the officer is. And if you're suing Geo Group, you're never going to find out, what the name is of who's in charge of that facility. So just list them by their title. It will greatly simplify your life. You talked about the standard form habeas petition. There is a great template petition put out by the Administrative Office of U.S. Courts. It's pretty comprehensive, and there's absolutely nothing wrong with an attorney using that form. I actually did one this week myself.
Some judges require it.
Yeah.
A judge in Houston literally will not take a privately drafted habeas petition. He wants the form that was approved by the Administrative Office of Courts. So in my experience now, I may just start using it, and the form is half designed for criminal prisoners. So when you're looking at it and you're like, oh, this is 3 pages, half of it is going to be not applicable. You really can fill out that form in 30 minutes and file it, and it's less time than filing a 7 or 8 page complaint version of a petition. So I'm at this point now where I'm just going to start using the form every time. I
think that's good. I would do your own petition if you want to write a lot of law, right? A lot of legal argument, but you could also attach that as a supplement to the standard form. Filing fee for habeas is $5.
That's so cheap.
Greatest money you'll ever spend.
I'll have it transferred to a different court, or I'll have to refile it. I'll just pay the $5 again. It's so low that it's not, and some courts won't even ask you to pay up front. They'll actually ask you afterwards when it's assigned to a judge to pay the $5. But $5, it's the best value in litigation.
That's right.
And some judges won't even make you do any summonses. They'll actually serve the ERO, the ICE office, for you. Other courts will make you file a summons and then you have to take care of it yourself. But habeas is the cheapest litigation that any of your clients are gonna, at least for costs.
Definitely. One thing you want to do is you want to verify your petition, which means at the end you want the petitioner or someone on their behalf to say, I verify that the facts stated in this petition are true. It's usually sworn under penalty of perjury, right?
Yeah, I often sign because if I'm not going to have my client review it, I'll swear to that as the attorney.
I'll get a family member more often because I don't want to make myself a witness in my own case, But if you have no other choice, then yeah, you might have to do it. You want the focus on habeas cases is getting them filed fast, right? So the key question, as you're figuring out what your claim is, what are you going to argue? The first question you have to figure out is, what is the statute that is governing their detention? And there's only a couple of immigration detention statutes. So first, there is INA 235B. That is for arriving aliens arriving at the United States, such as an international airport or a land port of entry. It also provides for screening for credible fear of persecution. If you're detained under 235B, there is no bond allowed. An immigration judge cannot set you bonds, regardless of how long you're detained. The only thing you can do is ask ICE for discretionary parole under INA 212D5. And that's not nearly as good as bond because you don't have a right to a hearing and you're arguing your case to an enforcement officer rather than a judge. But if you came in and you're under 235, then sorry, that's your only option is to get parole. The next statute is INA 236. This is the statute that provides detention authority during removal proceedings Now, not expedited removal proceedings, but Section 240, full removal proceedings. That's the most classic case for 236 detention. And under INA 236A, the Attorney General can release people on bond. You have to show that your client is not a danger to the community or a flight risk under a BIA decision called Matter of Guerra. One exception to 236A is 236C, which says that the Attorney General cannot grant bond if people have certain criminal history, such as convictions for aggravated felonies or even lesser crimes. Even potentially drug possession cases can stop your client from getting bond. Occasionally you see people like this detained for potentially years. The longest I've ever seen was 4 years on mandatory detention. INA 241 is the post-removal order detention statute. So while your removal proceeding is ongoing, you're under 236. After you have a final removal order, your detention switches to INA 241. What that statute says is that there's a 90-day removal period that starts after the removal order is entered, and then that can be extended for an additional 90 days. And so basically, the government gets essentially 6 months to try and deport you, and they're allowed to detain you freely, no questions asked, during that period. The ICE has some internal post-order custody reviews that they will do at certain intervals, but you don't. It's such a flimsy process. You don't, you don't get right to a hearing or anything. So, for your purposes, in most instances, those custody reviews don't really amount to much, right? But really, after 6 months of post-removal detention, that's when you get to start asking questions under a Supreme Court case called Zadvitas versus Davis, which
That's a hard Lithuanian last name to pronounce.
right. I say it Zadvitas, and I hope that's right. 533 U.S. 678, a 2001 decision. And what it says is that after the 6 months of detention, the government can only detain you if there is a significant likelihood of removal in the reasonably foreseeable future. That's a slurf, right? We call it slurf.
This comes up in the third country situation where you have withholding removal, you can't be sent back to Iran or Saudi Arabia, but then the government's going to say, well, we're going to send you to El Salvador, we're going to send you to Australia. There's other countries that are interested in taking you, and you're really then arguing over, are they making sufficient efforts to keep you detained or not?
Mm-hmm. And so one of the classic uses of habeas is if you think your client is being detained under the wrong statute. For example, I was involved in a class action in a Supreme Court case which determined which statute governs people who are in withholding only proceedings, meaning people were deported, they snuck back in, the order was reinstated, they were found to have a reasonable fear of persecution or torture, and then they're applying for withholding and CAT only.
Convention against torture.
Yeah, right, convention against torture. So ultimately the Supreme Court in Johnson versus Guzman Chavez found that it's the post-removal order detention statute, INA 241, and therefore there's no right to bond hearings for people in those proceedings. The due process clause of the Fifth Amendment also plays a big role in habeas litigation, and the best example is when it comes to prolonged detention. And here's the concept that has won in a lot of cases, and what you want to argue is that the due process clause requires a bond hearing when immigration detention becomes unreasonably prolonged. All right? So we see this idea winning most often in the 236C context, where someone has been detained with no bond hearing, for a year, 1 or 2 years, and it turns out that their only criminal history was a cocaine possession, a crime that didn't really harm anyone, and for that reason they've been detained for 2 years. A lot of judges will give you a bond hearing. They will order an immigration judge to provide a bond hearing, right? Now, occasionally you see that idea winning in as to arriving aliens detained under 235, and also as to 236A people who already had one bond hearing, lost, and then remained detained for some time. Now, arriving aliens and 236A, you get more mixed results as to this prolonged detention due process argument. It's really best in the 236C context. Let's say you had a bond hearing and the judge found that your client was either a danger to the community or a flight risk. Let's say you didn't like how the judge handled the evidence, you wanted him to disregard an arrest or consider some, positive evidence of your client's good moral character, and you're not happy with how the bond hearing was done. That is not a habeas case. Jurisdiction over such claims is barred by INA 236E, right? So if you're unhappy about your bond hearing, I'm sorry, habeas is not an answer for you. However, after detention is unreasonably prolonged, you might get another bond hearing under the Due Process Clause. And the threshold for prolonged detention is generally considered to be 6 months. However, courts will look at a number of factors to determine what is actually unreasonable, and there's different tests from different parts of the country. Habeas proceedings are supposed to be flexible. It's supposed to be a remedy that is available whenever someone is being detained unlawfully. It's a remedy that is adaptable to the needs of the moment. The classic relief that you get in a habeas petition is you get an order that your client be released. However, the judge can order any other thing that can alleviate the unlawful detention. So often we get a habeas judge, a district judge, ordering the government to provide a bond hearing before an immigration judge. That's a very common relief to get, even though it's not the classic habeas remedy. So really you can ask for whatever relief you want that is appropriate to the circumstances. Like, let's say, have my client transferred back to the jurisdiction, either pending the habeas petition or as the final relief. Often people will do things like that.
So the family can visit them so that they're closer to their home area. Yeah,
access to witnesses, access to counsel, those types of arguments.
Better venue.
Yeah, you don't want to say that, but that's might be what you're thinking. Two key cases that you should read. These are from the Guantanamo era. Well, I mean, we're still in the Guantanamo era. It never went away. But really, when Guantanamo was a hot legal issue post 9/11, there was a series of Supreme Court decisions. Hamdi versus Rumsfeld, 552 U.S. 507. That's a 2004 decision. You want to read that one. And then Boumediene versus Bush, 553 U.S. 723. That's a 2008 decision. If you want to orient yourself to a lot of the basic principles of habeas, you want to review those two decisions. Lastly, some additional resources. NILA, the National Immigration Litigation Alliance, has a fantastic practice advisory on habeas corpus. They also have a fantastic template petition, which I used recently. It's very good. And those are both available for free. And then the Amica Center, previously known as the CARE Coalition, they have an immigration habeas law index. It's like 70 pages, and it summarizes all the immigration habeas decisions from the last few years. So that's a little bit of an overview of habeas. There's a lot more that we could say. It's a very hot issue at the moment, but we've given you the tools to get started with some of it. Anything else, Brian, about habeas?
No, that's awesome.
All right. So get out there and challenge the government for their the way that they are expanding rapidly the immigration detention system, often without putting too much thought into it, right? So it's a very powerful tool. You should definitely think about whenever you have a detained client.